Since the advent of the early internet, the term cancel culture has snowballed and used to describe the various accounts of social, reputational, and economic fallout that have occurred in popular scandals and controversies. Cancellation is unique compared to other forms of unjust reputational or social damage, or forms of social damage that existed in pre-internet times. About a year ago, I made a video called A Fourth Branch of Government, Dialectical Forum, which was an essay about a political idea proposing a government structure that would address the issue of political division and the culture war. This video is similar vein, proposing a government structure that would address the issue of cancel culture. And the way we do this is through the introduction of a cancellation court. An important caveat is that we're not going to go into exploring the moral rights or wrongs of particular controversies or accounts of people being canceled. It kind of just doesn't matter who's been canceled or whether or not what happened was justified. The point is going to be to describe and understand the issue of cancellation as a process as a whole. Cancellation is a form of social or reputational damage or destruction that takes on a digital character or where the medium of digital mass communication serves as the primary vehicle for producing, accelerating, and amplifying the reputational harm. The digital medium's role is crucial to the definition. It doesn't merely circulate the narrative, but also cranks up the speed with which it circulates it and expands the reach and volume of who's exposed to it. These components are what make cancellation historically and legally unique. What sets it apart from other unjust attacks on reputation, unlike the traditional forms of defamation, are two things. Number one, the difficulty of attributing the reputational damage to a source, and two, the nature of cancellation as a process rather than an act with a multitude of actors. Point one, while many could argue that libel or slander could lead to reputational destruction, what sets them apart is that both of these forms, the source of the reputational attack is clearly identifiable, either a written or oral form, and the person responsible can easily be pinpointed, at least in theory. Right? This makes sense since libel and slander were developed as concepts in a time before mass digital communication existed, before anonymous networks of reputational attackers existed. These traditional definitions of defamation fail to appreciate the complexity of the digital paradigm we now live in. What sets cancellation apart is the damage cannot easily be delineated in terms of any finite number of libels or slanders by any number of people or legal entities. Thanks to the internet, much of the effects or causes of cancellation are carried anonymously through mass messaging systems on social media, comment sections, and ultimately unregulated channels of the social economy. When these anonymous spaces are the original sources of the defamation or defamatory remark, one cannot easily identify a discrete individual or set of individuals who can be liable for the wrong, since either there's too many, or you know that there aren't too many but they're all anonymous, or even if you knew the one that started it all, the account that started it all would have merely been the pebble that started the avalanche. They didn't actually do much, they simply voiced their opinion. And even if these online spaces aren't the original source of the defamation, but the source is identifiable, we nonetheless count them as being part of cancellation because they have the effect of amplifying the defamatory narrative through digital communication. Because this online digital component is so key to cancellation, along with its amplifying and exacerbating effect, the degree of damage necessary for something to be cancellation must also be high. In other words, cancellation isn't just when your reputation was hurt, but when it was so severely damaged that you suffer losses in multiple real life and social and career domains. Unlike libel and slander, cancellation has to be larger in scope and scale. Point two, the nature of cancellation as a process. In the philosophy of law, there's a concept of a victimless crime. What we want to do in defining cancellation is introduce the idea of a victimizerless crime. In other words, a crime with no victimizer, perpetrator, or criminal, right? This solves the identifiability problem. We call the person allegedly being canceled as the cancelee and the actors doing the canceling as the cancellers. The reason we say there's no criminal or perp is because the cancelers are always a countless multitude. They can't be identified. Even if the online actors who spread the narrative and got you canceled could all be identified, it's not that easy to attribute blame to them directly. Perhaps all they did was merely post one comment that started a chain reaction. It's the snowballing effect of mass media communication itself, the network coercion, and the popular narrative that the victim is a bad person that causes the harm. Cancellation is a process, not an act. It happens as a result of many actors interacting rather than any single action that any one of them does. In cancellation, there's two sets of actors. Small actors, or we could call them digital actors, and there's big actors. The small actors are all the people whose role in the process of cancellation is strictly digital. This includes anonymous accounts online, posting their opinions on social media, commenters on videos, people sharing, reposting, and discussing a narrative or scandal, expanding its reach. Perhaps this could include anonymous people sending information to an employer to try to get a person canceled, or spreading bad information about them to people that are affiliated with them. This could also include people who make false allegations, or allegations at all, but are anonymous. What this does not include is identifiable people who make allegations. Anyone who's identifiable who makes an allegation is not a small actor, they're a big actor. The big actors are the real identifiable legal entities that cut ties with the cancelee as a result of or in anticipation of the bad narrative circulating online, or any real-life actors who make allegations that harm reputation. So this would include a workplace firing their employee for mean tweets, a university canceling someone's lecture, a network canceling a show, a social media platform deplatforming someone, an institution stripping a person of their title, etc., or a person making a defamatory remark. Basically, every material entity responsible for the cancellation. The main difference between these two, as you can tell, is that the small actors are more on the digital side and the big actors are more on the real life side. But sometimes the line between them is blurry. There could be actors that are on both sides. But for the purposes of the theory, we can safely assume that there's two basic categories. Example of small and big, if you think about Harvey Weinstein's Me Too situation as a type of cancellation, the actresses accusing him of sexual assault would be big actors, business affiliates dropping him would be big actors, people discussing him online, or anyone making an anonymous allegation online who's unidentified, those would be small actors. Why set up these definitions? Because people will assume that the big actors share most of the blame and they should be the ones taken to cancellation court. But this is not the case. There's a tendency to think that the people who deliver the big blows are the ones that need to be blamed for someone being canceled. The way we're going to go about cancellation court is actually not to go after the big actors and absolve them of responsibility. The main reason is that the big actors, if they were really to blame, one could already sue them for defamation under existing defamatory laws, number one. Number two, the big actors are really going with the flow of the narrative circulating online. They're either anticipating it or acting in response to it. They're not really doing it by themselves. One of the key defenses of cancellation by people who defend cancel culture is that the people doing the canceling are well within their rights because they have their own reputations and bottom lines to worry about. And that is a good point. It's why cancellation is so hard to punish, because it's never one person doing it. It's many people doing it, and some of those people are really just protecting themselves or acting from their own subjective feelings, which they have a right to do. So, in order to address this issue of unidentifiability and the issue of it being a multitude of people acting in cahoots, acting together, constituting a process, right? You cannot sue or go after any discrete set of individuals or legal entities. Okay, the key thing to understand is that cancellation is not attributable to the big actors or the small actors, but to the interactions between the big actors and the small actors. In cancellation, we are trying to attribute legal blame to the aggregate behavior of a group that is amorphous and not well defined. So the idea here is that while the group is amorphous, the aggregate behavior of the group is very discrete and tangible. So in the case of someone being canceled, even if all the entities that do the canceling are within their rights from the perspective of their own private interests, which can be the case since people are just online or just sharing their opinions, the parties who deplatform or fire the person are just concerned for their reputation, the aggregate result is still deemed unjust by the cancellation court. This notion of aggregate legal responsibility in contradiction to individual responsibility is not paradoxical or accidental. Its justification stems from the idea that a society of individuals can be individually rational but collectively irrational, or acting in ways that lead to collectively irrational or unreasonable results. So, what sets cancellation apart from other crimes or civil wrongs is that it does not have an identifiable party that did the crime or wrong. The whole of society did the wrong, some unidentifiable subset of society at least. The wrong is done by all of society through the decentralized network of anonymous interactions online, the modern social economy. Essentially, even though not every person in society did something to get John Doe canceled, the fact that there is a subset of people in society that did do something to get them canceled through digital anonymity, and the subset is unidentifiable and numerous, or while the subset's actions were well within reason on an individual scale and were well within their rights, they were not within reason on an aggregate scale, means we can treat the whole of society as a legal stand-in for the cancellers. So that's the basic idea, right? Society or the people are a legal stand-in for the actual perpetrators of cancellation as a process. The setup of the court. The cancellation court can be set up as a regular court that handles civil cases, or a separate court entirely that only handles cases of cancellation. Whereas in the civil cases of defamation, there's both a plaintiff and a defendant. The key difference in the cancellation case will be there's no defendant because the wrong was done by all of society. You don't take a defendant to court, you bring the whole of society to court. The whole of society is treated as a legal entity because the act of cancellation is not attributable to a set of actors. Now, how is this possible? It works similarly to the way that a criminal case will work, where there's no plaintiff, but instead a prosecutor brings the case to court. Instead of the case being titled State of New York versus John Doe, it gets called John Doe versus the State of New York. Instead of a state prosecutor, you have a state defense attorney defending the state or the people against the plaintiff. And John Doe, instead of being accused of a crime against the laws of the land, is accusing the people of committing the civil wrong of canceling him. And for clarity, we can just call cancellation cases John Doe versus the people, since the state had nothing to do with it, technically. This flipping of roles isn't strictly formal. It represents the fundamental meaning of cancellation itself. A person who is cancelled is a victim, but they're not a victim of a distinguishable set of actors. They're also not a victim of a single action or set of actions. This is the fundamental feature of cancellation, is that the reputational attackers are unaccountable while the reputational damage is real. So how is the court going to proceed? Well, the court proceeds the way normal civil cases do. The plaintiff brings the case and they have to demonstrate two things. Number one, that they were canceled, that the act of cancellation was done to them, which we're going to define later. And two, that they cannot attribute what was done to them by any party that counts as big actors, i.e. each party that fired them or deplatformed them or cut ties was well within their right. If not, the case can be dismissed and bumped down to a regular civil case. If the big actors did something defamatory, the plaintiff is forced to sue them for defamation or go after the parties to whom the wrong is attributable. Point two sounds like proving a negative, but the plaintiff goes about this by proving the positive, that they were canceled by the process of networked anonymous interactions and virality. However, in some cases, the defense can use that the defamation against the plaintiff was done by a particular party or journal and use that to bump the case out of court. Next, of course, if the plaintiff wins, they get compensation from the court in the form of money. Sometimes they can push to have their position, role, or job reinstated, forcing a company to rehire them or a platform to replatform them, etc. The latter possibilities are going to be reserved for the most extreme cases. The minimum result is compensation for the plaintiff. If the plaintiff loses the case, he's either dismissed or forgotten, the case is bumped to a lesser court, or the plaintiff is forced to compensate the court for wasting its time. This last criterion is to prevent frivolous cancellation cases. The proceedings of the cancellation court will fall into three categories or types. What the plaintiff has to prove and demonstrate depends on the type. Type A, false statement where no defamation occurred by identifiable legal entity. So this is the standard case. A false statement was made about the plaintiff, or a false narrative was spread, or a false narrative with malicious intent. If it's a celebrity plaintiff, the plaintiff has to demonstrate this. They have to demonstrate defamatory meaning. They have to demonstrate that it was published online, and they have to demonstrate that it clearly identified them, the plaintiff. Two, the plaintiff has to demonstrate damages, that the reputation was harmed. Now those first two things, those essentially cover what happens in a standard defamation case, or what a plaintiff would have to prove in a standard defamation case. But after that, it starts to differ. Number three, the plaintiff has to prove that a significant part of the damage is attributable to a network of anonymous actors and internet virality. For something to be cancellation, the internet has to play a role. If you can attribute the false statement to a journal publication, an individual or legal entity, it becomes standard defamation. This virality criterion can be proved in several ways. One can make reference to the number of comments, the number of views or upvotes of certain comments, the amount of reach of certain videos, anything and everything online that circulates the false narrative and demonstrates volume. And then number four, right, to go along with number three, the plaintiff has to show that the damage attributable to the online circulation of the narrative is beyond a reasonable amount, that the online circulation amplified the reputational damage beyond a reasonable amount. So there is a reasonable amount threshold threshold, a proportionality or disproportionality threshold, if you will. Why is there a threshold criterion? Because obviously anything can be damaging online, but doesn't count as cancellation if it doesn't reach a certain level. If anything circulating online that's misleading, causing any damage or harm, as little as hurt feelings and bad vibes, is now a legal liability for the state and as taxpayers, well, that means that nothing can be said or made to circulate online at all. No, indeed, free internet means that false information can circulate too. It's only when that false information damages things, goes beyond a reasonable amount, that the justice system is allowed to step in and give recourse to someone harmed by it. Now, defining this threshold is a very, very, very tricky thing to do, and it's not something we're going to do here. It's outside the scope of this video. But you can see from the way that type case A is laid out, points 1 and 2 clearly mirror what a typical defamation case would look like, and the case would proceed similarly to that. Points 3 and 4 are the additional things that a plaintiff has to prove in order to demonstrate that cancellation occurred, because cancellation is more serious than mere defamation. Type B, false statement where defamation occurred by identifiable legal entity, but cancellation still occurred. So this is similar to type A, except in this case, you actually can identify someone who made a defamatory remark that was part of the process of cancellation. So for number 1, it's the same as A. Plaintiff has to prove that a false statement was made, including defamatory meaning, published online, clearly identified the plaintiff. 2, same as A, that damages to their reputation occurred, that they were harmed. 3, same as A, plaintiff has to show that a significant part of the damage is attributable to a network of anonymous actors. And 4, that the damage attributable to the online circulation is beyond a reasonable amount. So all of the steps are the same. The only difference is that in case A, the plaintiff can't identify anyone that did anything defamatory that they could sue for defamation. In type B, they can. Now what this means is this type B only differs in that there's no additional parties that could be getting sued for defamation. In type A, the defense attorney could throw the case out of court if they could find a person who made a defamatory remark that the plaintiff should have sued for defamation. But basically what type B means is that, let's say Bob made a defamatory remark about John, and the defamatory remark caused John to be canceled, meaning that the damage was disproportionate, right? It passed that proportionality threshold. That means John now has the right to both sue Bob for defamation in regular civil court and go to cancellation court under type B. And under type B, the defense can't just throw the case out because Bob did do something defamatory. The idea here is to give more rights to a person who's a victim of cancel culture, and to say that under very serious cases where a lot of damage occurred, okay, it doesn't matter that they can sue someone for defamation, they have an additional right to sue for cancellation as well. Obviously, thinking about the proportionality threshold for type B cases must be much higher than the disproportionality threshold for type A cases, okay, because type B is more serious. Type C, non-false statement, but damage still occurred. So type C is even broader type of cancellation where the statements circulating about the plaintiff weren't even false, meaning you couldn't possibly sue anyone for defamation because they never said any false statements. In this case, what the plaintiff has to show, they has to show that the non-false statement that was made about them or a non-false narrative was spread, the non-false narrative harmed their reputation, had a defamatory meaning, was published online, identified the plaintiff, etc., just as before. 2, they have to show that damages occurred, that their reputation was harmed. 3, a significant part of the damage is attributable to a network, just as before. And 4, the damage attributable to the online circulation is beyond a reasonable amount. So similar to type B, if the damage is beyond a reasonable amount and done by an anonymous network, cancellation has occurred even though the narrative was not false. So they just have to demonstrate that a narrative harming their reputation was spread about them, and that the narrative did so much damage that it crosses that proportionality threshold, and it counts as cancellation under type C. Now, this particular case applies to cases where a person rightfully had their reputation damaged or attacked, but it was attacked too much or to an unreasonable degree. So why do we have type C? Because the idea of cancellation as a moral wrong is that someone is being reputationally punished in a manner disproportionate to whatever they did. Cancellation is a historically unique form of reputational destruction because a person has no recourse, and the virality that accompanies it and the peculiarity of the the internet world, where anyone and everyone has instant access to information about a person or a scandal, has a much different effect on an individual than in previous eras of history, where information was a lot more limited, didn't travel as fast, and was not readily available all over the globe. In the old world, a person could have their reputation destroyed and not have the world turned against them. But in the internet world, a person has their reputation attacked and the world can turn against them. Theoretically, the idea stems from the intuition that in the past, if you had your reputation destroyed, you could always leave town or move to another country and start anew. But in the internet world, you can't really do that because all the information about you follows you and is available everywhere because everyone has access to the internet, right? You're kind of always being watched globally by the herd, by the anonymous, unaccountable network of people plugged into the internet. So it creates this weird kind of Big Brother situation where people are always being watched, but not by the state, but by other people, by a decentralized, amorphous mass of others, which still isn't a good thing, right? So you have to understand that defamation laws and ideas about protecting social reputation were developed at a time in history where social conditions were very different. The idea of cancellation is one where a person may very well be guilty of whatever narrative is circulating about them, but the damage is still disproportionate, hence they deserve legal recourse. So an example of this could be someone like Harvey Weinstein. If Harvey Weinstein's cancellation case, it would qualify as type C, because while he is guilty of the narrative circulating about him, the damage may still be disproportionate. I'm not suggesting that Harvey Weinstein was rightfully or wrongfully canceled. I'm suggesting that if Harvey Weinstein decided to go to cancellation court, he would have to sue under type C. This idea fundamentally asks society to consider the possibility that in the internet age, we can be guilty of a wrong and punished for it unfairly because of how many people have access to our lives through digital information. The truth about a person in the digital world is unjust even if it is the truth, because in the digital world, because the digital world itself is unaccountable, its judgments and temperament about a person are also unaccountable and unfair. So you can see that a lot of this whole cancellation court idea hinges on the idea of disproportionality and disproportionate damage. A cancellation case occurs even if the person was guilty of whatever narrative or statements that were made about them. Even if a statement of fact is true in a given case, but damage is still disproportionate, cancellation event occurs and someone has to pay. The idea requires people to take seriously that the court of people's opinions on a subject alone in its cumulative effect is enough to cause enough damage that a moral wrong occurred to the victim of those opinions. Now, this doesn't mean that there's no such thing as a universally hated person who is guilty of a wrong or crime who doesn't deserve to be universally hated or reputationally castrated by society. Such a person would simply be the loser of their cancellation case. A cancellation court such as this is merely the admission of the idea that there exists such a thing as a person who is universally hated, guilty of a moral wrong or crime, and still not deserving the amount of universal hatred, reputational attack, and social damage that occurs as a response, right? The idea is really that we're trying to hold society as a whole accountable for its hysteria and outrage at particular scandals. The mass of people holding individuals accountable are not being held accountable themselves by anyone. And the fact that they're able to interact online where there is a veil of anonymity kind of protecting them, their dynamic and their expression of their opinion is kind of innately and intrinsically unaccountable. So the unaccountability kind of cuts both ways. Concerns and considerations for the cancellation court. So obviously there's a lot of things to consider with this conception of a cancellation court and a lot more work that needs to be done to develop and flesh out the idea. Number one is the idea of disproportionality. All cancellation cases hinge on the idea of disproportionality, but most of them will likely fall into type C, which hinges on it the most. The terms of disproportionality have to be announced and upheld by the state. These terms have to be defined and fine-tuned very carefully and meticulously for the court to work. We don't have an exact idea of what this disproportionality threshold is right now, but there's obvious considerations. Some of the considerations, namely in cases of type B over A and C over B, cancellation is determined by disproportionality more than anything, meaning damage must be quantified, at least in part, and shown to be disproportionate. Clearly, the threshold of proportionality will vary by case and case type. In cases like type C, the threshold must be higher than B, and in cases like B, it must be higher than A. And for particular defendants who are accused of greater moral wrongs in the public opinion, the thresholds must be higher. The threshold for a hypothetical cancellation case of Harvey Weinstein with the Me Too movement would be higher than the threshold for Louis C.K. or Dave Chappelle making a transphobic joke in stand-up. The disproportionality threshold may be a variable acceptable quantity. The court may devise a mathematical formula to determine where the threshold of disproportionality lies as a function of each defendant's particular level of fame and circumstance. Political and cultural consideration. While this conception of a cancellation court is politically neutral, i.e. members of any political party may be cancelled for their views, left-wing, right-wing people, liberals, socialists, fascists, etc., what matters is the disproportionate reputational damage carried through the digital medium. Nonetheless, political opinion havers will complain that such an institution will inevitably be captured and factionalized by some group of ideological radicals, rendering the institution unfair. This consideration is rather innocuous in my opinion, since any institutional change is susceptible to this risk. We're not building new institutions in order to prevent some long-term possibility of them being ideologically captured. We are building these institutions because we believe they make ideological capture harder in our current world. Indeed, a cancellation court, bound to the principles delineated earlier, would make it harder for the ideological capture of quote-unquote woke forces that the right-wingers ultimately fear. Damage and costs. Obviously, a cancellation court cannot repair the full damage of a person having their life destroyed by cancellation, nor is it obligated to. Such court cases will incur a taxpayer cost, as obviously Treasury funding that funds the Justice Department of a nation will have to fund the cancellation court. It's important to ensure that the cost of the court is not too great, that proving cancellation is not too easy for the plaintiff in order to extract money from the state, which will be no small amount given how potent these cancellation incidents are. The state is obligated to compensate victims of cancellation, but not compensate them to such a degree that it would bankrupt the state. This will require a careful balance where cancellation cases are hard to win for the average plaintiff, but lucrative enough if won for the worst of scenarios. Locality. The locality of an anonymized network of digital actors amplifying the reputational damage causing the cancellation is an important point. It is possible that the network of interactions that constitute the digital process that leads to a person being cancelled are not made by parties under the legal domain where the cancellation occurs. Example, a person is cancelled in America because of mass communication about their scandal in India. Such an example is rare, since it's usually local cultural sensibilities that lead to cancellation, but not impossible. Imagine a country like Russia using bots to promote a misleading narrative about an anti-Russian celebrity leading to their cancellation. So the cancellation court must have to account for where the primary source of the anonymized online digital activity amplifying the reputational damage is coming from. Is it coming from the court's own jurisdiction? Perhaps if it comes outside the court's jurisdiction, it isn't the court's responsibility to adjudicate it, and an international cancellation court needs to be set up to address such eccentric cases. Although, in my opinion, it doesn't really matter where the online interaction is coming from. If the online circulation is happening in America, outside of America, all they have to prove is disproportionate damage occurred, and now they were canceled. It only creates a problem if the international bots that are canceling people all the time, and now the court has to pay a ton of money. Symbolism. Part of the purpose of the court is symbolic, to admit that society has earned a moral wrong in allowing such an event to occur to the plaintiff. Repairing the damage in its entirety is an impossibility, and the court can at most offer some compensation. However, this symbolic role is important because it will create a path to becoming uncancelled for the plaintiffs, meaning if the court cannot give a plaintiff all the benefits of undoing their reputational collapse, the mere fact of winning a cancellation case awards the plaintiff with a certain prestige, effectively redeeming them and signaling to future employers, associates, and opinion havers that they have been redeemed in the eyes of society. The cancellation court serves as the perfect counterweight to society's propensity to having unreasonable outrages about scandals and individuals. The idea of cancellation is obviously a challenge both to existing political legal doctrine, foundations of existing law, and common ideas of ethics, but it is a necessary development in the digital world of the internet where information circulation is uncontrollable and accelerating at an inhuman pace. Regardless of the specifics of this court, such a development would be necessary to challenge the externalities and costs of living in a digital age where the pace of information circulation, reputational damage, and social economics and human feelings are moving in chaotic directions. It will also help to alleviate the big brother feeling of living in a digital age where you're always being watched, only not always being watched by the state, but always being watched by the herd, as if the herd is somehow less malevolent than the state. No, indeed, having your private scandal exposed and judged by all of society, having all the fingers pointed at you, is kind of like being pantsed in the middle of the classroom. It's not a pleasant feeling, and indeed, such a court would alleviate this feeling and produce a culture where people can actually behave more freely because their scandal scandalous affairs are not something that is exposed to the whole of society and they are left to rot within that fallout. The developed liberal nations who attempt to develop such a court will, in my opinion, begin to move beyond liberalism and into a new type of social system, one that is built for the digital internet paradigm. This and other similar ideas like the fourth branch of government posited in my earlier video are also part of this process. I believe developing these institutions is the solution to the contradictions and flaws of modern liberal societies and a real progressive path to the future of humankind. These post-liberal developmental notions are politically hard to categorize as either left or right-wing, nor easy to factionalize or tribalize, but they may be the key to solving the political divisiveness, faction, and more broadly, so to speak, madness of our messy, modern, postmodern world.